I'm Gantavya Vashisht, and with CLAT SARTHY today, we're going to be talking about the Transgender Persons Amendment Bill 2026. Imagine if the state told you that your identity is valid only after a medical scrutiny, a medical approval. Is it a step towards better regulation, or is it a rollback of fundamental rights? Let's break it down in the simplest and most exam-relevant way. The Transgender Persons Amendment Bill 2026 was introduced by the Ministry of Social Justice and Empowerment, and it proposes major changes in the 2019 law. It was tabled by Dr. Virendra Kumar, and here is the controversy. It dilutes the right to self-identification to the current 2026 bill. Now, 2026 bill goes even further. It shifts from the rights-based approach to a more regulatory and medicalized approach. The key changes, if I talk about, and the first one is removal of self-identification. Earlier, you could identify your gender yourself, and the district magistrate would issue a certification based on the affidavit that would submit. But now, this is completely removed. This impacts the autonomy, the privacy, and the bodily integrity of the trans community. Secondly, medical certification is introduced through a medical board. So now a medical board would certify the gender identity, and the process is the medical board would send a recommendation to the district magistrate, and who would, based on the recommendation, further issue certification. Now the problem is that it becomes more of a medical condition and not a personal right. They have, in the third thing, they have narrowed down the definition. Includes Hijra, it includes Kinnar, it includes Aravani, the intersex and the biological traits. And it completely excludes the non-binary persons, the trans men, the gender fluid individuals. And right here, I would also like to quote the change in the definition, which I think is very relevant. Trans means, and inclusive of all of that I've mentioned you, the provided says that it shall not include, nor shall ever have been so included, persons with different sexual orientation and self-perceived sexual identities. So it's very important to mark here that this may wash off all of the identities of the gender fluid people, of the trans men and non-binary people who have even got the identities, because here they say which nor shall have ever been so included, so they want to wash away it completely. This may also create a hierarchy within the community. There's an argument going on about the genuine beneficiary, where the government says that earlier law was too broad and it included everybody, but the critics argue that who decides who's trans enough? So this raises arbitrariness under Article 14. Then the next provision is that they have conditional name change, where you can change your name in identity documents, but only after a very strict laid down conditions, and you have to fulfill them. Rights become very conditional and they're not inherent anymore. The increased bureaucratic control. The National Council will now be dominated by senior officials. The designation which has been allowed is of a director. There's less community participation, more of top-down governance. Another provision that's been added is criminalization of forced identity, which is a positive step. I mean, it protects against forced transitions, but a lot of vague terms have been used, like inducement, allurement, There's also a risk which everybody is talking about, the risk where NGOs or families or people, well-wishers of transgender, it could be misused against these people. Examples of Gauri Sawant has been taken, where people are saying, feeding basic medication could also be covered here, and the law here could be properly abused against the well-wishers. Another provision is the punishments have been enhanced, which again I appreciate, because in the 2019 Act, the maximum punishment was up to 2 years. It was like the punishment was bracketed under 6 months to up to 2 years. But now the punishment has increased to up to life imprisonment, and in some cases, and obviously heavier penalties, heavier fines. So if earlier an offense of, say, abuse or violence would have been committed against a trans person, so the punishment was between 6 months to 2 years, and now it has been increased to up to life imprisonment in cases of brutality, in cases of gruesomeness. The forced begging, earlier it was minor penalties, but now it's between 5 to 14 years. The focus has really shifted towards criminalization against the abuse against the trans people. I also feel that we need to discuss the constitutional issues. Like, for example, I feel there's a problem where this bill contradicts with Article 14 and the dual test that's been laid in Article 14. So it fails the intelligible differentia, it fails the rational nexus. I would really like to talk about the classification here for you. The classification is founded on intelligible differentia, that therefore it has to be logical, it has to be reasonable, and it doesn't have to be an arbitrary one. Secondly, the differentia has to have a rationale with the nexus or the purpose of the statute. Now here I fail to understand that by excluding trans men or non-binary people or self-identified people, I don't see the differentia that's been created is rational. The relation between the two is also missing, and inclusion of some and exclusion of the rest, especially the ones which were recognized before and now deemed to be unrecognized under this new bill, it makes it arbitrary, it makes it very unnecessary. If I talk about Article 19, Clause 1, Subclause A, which talks about expression, then if we talk about gender identity is expression as per the Nalsa judgment, then restricting identity will amount to restricting freedom of expression. Now here it's very important that I quote to you the exact phrasing which was used in the Nalsa judgment. I mean, it's very beautiful and it's very important that I quote it. Gender identity, therefore, lies at the core of one's personal identity, gender expressions and presentation, and therefore it will have to be protected under Article 19, Clause 1, Subclause A of the Constitution of India. A transgender personality could be expressed by transgender's behavior and presentation. State cannot prohibit, restrict, or interfere with the trans expression of such personality, which reflects the inherent personality. Often the state and its authorities, either due to ignorance or otherwise, fail to digest the innate character and identity of such people. We therefore hold that the values of privacy, self-identity, autonomy, and personal integrity are fundamental rights guaranteed to the members of the trans community under Article 19, Clause 1, Subclause A of the Constitution of India, and state is bound to protect and recognize these rights. Now here, the para 66 that I've quoted to you of the Nalsa judgment, it talks about this could be through their behavior. Now, how can one ignore the part where if somebody identifies themselves as gender fluid or non-binary, then it could be through their behavior, it could be through their presentation, but which is not recognized in the present bill. So going further, if we talk about Article 21, right to life and dignity, it includes privacy, autonomy, identity. Medical certification clearly violates dignity. It violates the privacy of the person as well. It also is in conflict with Article 15 and 16 because protection against discrimination, and it's an affirmative action. Bill may weaken these protections. If I talk about how it is in conflict with the Supreme Court judgments, and I've already quoted about the NALSA versus Union of India, but I would also like to quote Justice K.S. Puttaswamy versus Union of India, which talks about privacy includes identity and autonomy. I also want to talk about Navtej Singh Johar versus Union of India, which recognize dignity of gender identities. If I talk about the international perspective, then globally, countries like Argentina, Malta, they have self-ID model, and I feel medical certification is very outdated approach. India may be moving backward. If I talk about the ground level impact, existing beneficiaries, which are up to over 32,000 ID holders, may need recertification. There are already barriers, the rural India, the lack of medical boards, the social stigma, the mental pressure, the psychological pressure, and lack of the health infrastructure that we already have. I feel this may take another blow. If I talk about the informal sector impact, then most of the transgender people work informally, where documentation is the barrier, and that leads to further exclusion. But now that self-certification is off the chart, getting a certificate through the district magistrate after the state board the medical board will become another big hustle. If I talk about the way forward, then I feel that restoration of self-identification is the way to go. We have to adopt a hybrid model. We have to make sure that there's ample medical support. We have to expand the definition and make sure non-binary people and gender fluid people are included. We also need to focus on the welfare, the education, the healthcare, the jobs of these trans people. We need to sensitize the police and the judiciary. So if I have to bring it to a conclusion, then I think the real question is, should identity be self-declared or state certified? This bill is just not about law. It's about dignity, the autonomy, the meaning of equality in India. Thank you so much for watching. Thank you for listening to us, and I would really like to hear your views on this. Share this and let us know your views. Thank you.